And what do you do to ensure that a global company uses, when it's using a loan mechanism, which is what they all tend to do to try and get their tax liabilities on low tax jurisdictions, when loan mechanism to export its profits in the UK, but they don't use the same interest rates as they do on loans that may be given to other European countries, which strikes me as being aggressive tax avoidance. What do you do in those circumstances?
Well, in some of those cases, we take action against them, and I think there have been a number of film rights companies where I think Eclipse.
Well, that would be one.
Where large interest payments.
I'm really, that's where individuals benefit. That was what was in the papers last week. I think what we're after is the corporates this week.
Can I pull apart two issues, Chair, please, here? First, the volume of interest. The UK tax system, the policies underpinning it, see relief for interest as one of the things that makes the UK competitive. There are rules which cap it, but the UK, in terms of interest relief, is more competitive than many countries. The second issue you raise would trigger an investigation by my department very quickly indeed, and that is if the rate of interest was being, may I use a slightly loaded word, manipulated to create more relief, we would start a transfer pricing inquiry very quickly indeed, and we have some of the best transfer pricing experts in the world.
Can I exemplify this with a case that has been in the media, Chair's point, which is the Northern and Shell Group, who apparently, according to the media, effectively have all their debt in Luxembourg, charge interest to the UK, more or less extinguish their profits in the UK, remit the interest to Luxembourg, which of course is a very low tax regime. That case has been in the media.
We don't come before you to talk about individual cases. I think what I would say generally is that the business tax division of HMRC, which deals with the largest companies and their tax affairs, does generate 60% of the tax that the country takes in. We collect 470 billion a year.
That's just not the point. Well, just not the point. The point is each individual taxpayer dealt with fairly before the law, so that we, all the other taxpayers, all the small businesses in our community, all those sort of people feel that when they pay their tax and they're pursued by you to the nth degree, everybody is treated equally with the law. And you read this sort of Vodafone, I know you can't discuss Vodafone in detail, which is why I asked you to in a systemic way. You read that and you think, goodness, there is something, really, really wrong in the way that we deal with these big corporations.
Well, I think we share your concern that the public will worry about whether tax is even-handed, but we don't believe there is anything about the way we deal with any cases that is less than fair and even-handed. And we seek to apply the same laws in ways that are appropriate to the cases in hand, and there is an element to which you have to have different tools and techniques for different circumstances. It would be impossible for us to have a customer relationship manager for every small business, but in just the same way as we do with big business, we work very hard with small businesses to help them pursue a successful economic undertaking whilst keeping their tax affairs in order.
But on this question of having relationship managers for big businesses, can you, many small businesses will say, well, we struggle to get on the phone to HMRC. And so, of course, it adds it's a benefit to ensure that these procedures can happen more easily. Can you give us an example? In the case of Vodafone, their argument is that they paid a large amount for the 3G spectrum in 2000, and their interest charges on that debt taken on to pay for 3G spectrum are very high. But are you saying that the customer relationship manager with Vodafone would therefore take that into account in the way that they settle the tax would they agree what the appropriate tax bill for Vodafone is?
Not at all. Greater
Well, they wouldn't take into account the amount of interest.
We apply that policy.
1, 2, 3. It's Richard, Stephen, then Stuart. And we're going to have to come back after
From
that.
what Matt was saying earlier, the individual John Connors, who was a senior HMRC official, had a role in relation to large business tax. What was his final job at HMRC?
Yeah, I'm afraid I don't.
But it was large business tax, was it not?
It wasn't operational.
What was it?
Mr. Bacon. He was the director of the large business customer unit. So he was...
What does that mean?
Well, I'm just about to say he was developing strategies for how we related to large business, how we involved with them. He would be advising on policy issues, compliance structures, and that sort of thing.
Right, so the Reuters piece that says Vodafone boosted its tax team in 2007 by hiring the head of an HMRC unit that dealt with large corporations.
That's
John
not
Connors.
correct.
That is correct.
That is not correct.
That's not. He didn't deal with large corporations.
Did not deal with large
He did the policy in relation to large corporations.
That sort of thing, yeah.
Yes, okay. And then he went to Vodafone.
Yeah.
Was there a gardening leave period between his leaving HMRC and his going to Vodafone?
I think there was a short period, but there was a very specific consideration, as there would be with anybody, as to whether that was a proper thing to do.
How long was the period?
I'd have to look. I'm sorry.
Could you let, what would normally happen? I mean, you've got a large number of staff. There are tax experts there whom companies will want to hire. What would be normal?
It will depend on the circumstances. If you look generally, quite a large part...
Somebody who's worked at a big business set
Yeah.
and goes off, to poach a turn geek.
Can you make the phone call while we're voting?
Yeah.
Find out.
And we're reconvening.
Instead of
I'm told,
note.
folks, 5:15 on the dot. If you are ready.
Thank you. Could I turn to Company D, which most people accept is Vodafone, but I understand you want to refer to as Company D. When you made the assessment ahead of the settlement of what tax they were liable for, what time period was that covering?
Can I check, is this the point you discussed yesterday about whether future issues were involved?
Well, I want to come on to that, but what I'm
Right.
not there
Yeah,
as yet. I would like to take an earlier step, which is ahead of your settlement negotiation with Company D. I assume you made an assessment of what you thought they were liable for.
Yes, the principles that we apply in the cases that we put through our litigation and settlement strategy are that we seek through the work we do with the organisation to establish the right amount of tax that is owing, and then we seek to settle for the level that we believe we are due. And so a judgment is made as to what that amount is. Now, I think you have to accept that that may not be a figure that you start with that then stays constant all the way through, because what happens as you do the discussions is you...
Of course, in a negotiation, the figure won't stay the same. With respect to Sam, it was a very straightforward question. If I may, could I repeat it? When you made the assessment as your starting point in the negotiation as to what tax you thought Company D was liable for, what period did that assessment cover?
up to 2008.
Up to 2008. When you then settled with the company, what period did the settlement cover?
The settlement covered that period.
Right. What settlement was reached with the company in terms of the period post 2008?
I think I'm going to have to refer that one to Dave, because I think this is the conversation you were having yesterday when I think both Amius and Andrew Park were unsure about what was in and what wasn't, and that was the question I was trying to ask you at the beginning.
Which you knew about yesterday, so I assume Mr. Hartnett's had a chance to check that.
The position, Mr. Barclay, was that provided there was no change in the CFC position from the position as 2008, the 3 years, 9, 10 and 11 would benefit from the CFC exemption.
So you would not claim tax over 09, 010, 0, and 2011.
I don't. Can I be just slightly picky, but I'll do it very quickly. I don't think we ever committed not claiming tax.
No, because you
Committed
can't
on
bind
no
yourself.
change. That could be
You can't bind yourself. But you indicated to the company that you were inclined not to claim tax for those 3 years.
If the logic we had applied in reaching the settlement stayed,
All things
it would
staying
stay through the next 3 years.
Yeah. So when you came to that decision, did that include a assessment, and was it documented ahead of reaching that decision as to what you thought the tax liability would be on the 2 controlled foreign companies operating in Luxembourg, the one dealing with the European investments and the one dealing with the US investment? Did you break that down in one of the documents you prepared ahead of the settlement?
Yes, I'm slightly concerned that we're reaching the kind of territory that would have been better discussed in a private hearing.
Willing to give us that information in private?
I haven't actually asked what the amount was. I'm asking with respect about the process. I'm asking
Well, I
to
think
what extent...
if we're talking about procedure, then I'm happy that we should try and answer.
So what I'm asking is, if you're saying all things staying equal, we will not take tax for future years, what I'm trying to understand is, in coming to that negotiated position, what your assessment was beforehand and whether that was documented and broken down as it applied for specifically the 2 Luxembourg foreign control companies.
The answer, Mr. Barkley, I think is in paragraph 49 of the NAO report.
Yep.
The answer, I think, is in paragraph 49 of the NAO report.
No, that says it was considered. What I'm saying is, did you document
Better read that
anywhere?
out so that everybody knows what we're talking about.
Mr. Hartnett?
In paragraph 49, it says there were subsidiaries in the same country as subsidiary D. The department considered whether the controlled foreign company provisions applied to those, but put simply, Mr. Bartley, we did consider Luxembourg, and it is documented.
I wouldn't begin to think that you didn't consider.
Of course.
It would be so glaring an omission.
I think so.
To suggest that. So once again, that wasn't the question with respect.
Sorry, I thought...
I'm asking about the process. Did you document ahead of the settlement negotiation an estimate of what you thought the tax might be in 09, 10, 11 for the 2 controlled foreign companies operating through Luxembourg?
We'll have to come back to you for a simple reason that, as I explained at a previous hearing, the work was being done by our most senior experts. I want to check. I'd be guessing if I gave you an answer to the question.
Because I raised this yesterday. Ms. Homer was in the hearing about my concern around the forward element of it, but we haven't got the notes that was prepared at the time.
Well, I was in the hearing yesterday, and my understanding was that you were asking questions about the generality of whether future issues were involved, and that's what I took it to be. That's why I was trying to get some understanding. I'm very happy that we'll give a note to Mr. Brock.
I'm trying to understand how you made a determination of what the tax liability would be for 2011. How that assessment was made, other than Vodafone as part of a deal saying, well, this is as much as we're prepared to offer, take it or leave it. And what I'm trying to get to is your assessment and how that was documented and assessed prior to going into that negotiation.
I think what we're trying to do is explain a procedure to you, and the procedure that we followed was to make a judgment on the type of tax position the company was in with relation to subsidiaries, and then make a judgment about the tax owing as a result of that. So it seems to me that we're describing to you a process by which we reach a position on tax due, which then leads to an application. Now, that isn't the same as trying to forecast profits, and that's the bit I think that we're in some disagreement disagreement about.
But you can't take tax on an arbitrary basis, can you? So are you satisfied that all aspects of that forward element was compliant with the Al-Fayed judgment?
We're satisfied that the comment made that if all things stayed the same, if the judgment we made on D was right,
No, but the whole
right for the next 3 years.
Again, with respect, I would have thought that's a fairly yes or no. Either it is compliant with Al-Fayed or it's not. I understand you made it on the basis of at that time things staying the same. The point with Al-Fayed was things didn't stay the same.
Well, and that the only decision we made was if they stayed the same. So, I'm sorry that we keep going round and round, because we think our position is quite simple, quite well described by the judge, and is about if the judgment we're making is the proper judgment, and if the circumstances remain the same, it will remain the right judgment for the future.
Right.
That's a policy point, if I could put it that way, not a judgment about amounts that is traded off. We're not in the same place about the procedure that was being followed. And that is our position. There was some debate yesterday between yourselves and the judge about whether or not we were negotiating and reaching a view. But our strategy is clearer and sharper than that. And that is that
But how can you decide that, Lynn, if you don't take legal advice?
Well,
I mean, it's quite extraordinary. The whole thing, there's billions. I mean, it's a more general point. Some of these deals are for billions. The one for Vodafone is billions.
Well, let me
you don't
respond
take
to
legal
your
advice,
question.
and then you tell me to believe that you think you'll lose the point in litigation. I can't. It's an incredible position.
Let me respond to your question then. First of all, we find out by having a dialogue, which often includes quite significant disclosure, so that we end up with more information to make that judgment. And secondly, we reach that point by using the expertise that's appropriate. And again, have to say I'm in the same place that Andrew Park was on this. That will sometimes be legal, that will sometimes be deep technical knowledge, that will sometimes be generalist knowledge. And I think the comment the judge used yesterday was, I think we'll have to differ with you on this. I think a highly technical tax professional is often going to be the right person to make those judgments.
What is odd about this, just a second here, what is odd about this is not only did you not seek legal advice prior to reaching the settlement, which is what paragraph 2.30 addresses, but also you didn't get sign-off, as paragraph 2.41 makes clear, afterwards, even though it met the criteria requiring sign-off. So that's what seems extremely odd, that both beforehand and afterwards you failed to follow procedure.
Well, I've already indicated, Chair, that on the governance issues, I accept, I think, the clear guidance NAO and yourselves have given us, that our guidance...
We did, actually.
Well, you gave us, apologies, I was sharing the credit, that you've given us before, that our protocols should be clearer, our role separation should be clearer, and indeed that HMRC needs to have more tax professionalism at the top of its organisation. Now, I think those are all points that were well made to us, and my propositions to you do intend to take those forward. So I would accept Mr. Barclay's point that we should more consistently not only be clear about what our governance is, and we should stick to that. And your debate yesterday about whether there was specific governance or ad hoc governance, I think is a criticism fairly made of us that we will seek to improve.
Wait a minute, I've got Stuart waiting patiently.
Can I just on that very... We as a committee have not seen the details because of the catch-all point of disclosure and confidentiality incumbent with the legislation, and we don't know about the capacity and capability issues of your very senior lawyers and tax advisors as to whether they are proficient enough or skilled enough or experienced enough to take on these very, very accomplished and well-paid tax lawyers, the sort of people that are employed by Vodafone and Company E, the name of which we all know. So you can see from our point of view that it's very difficult for us to give carte blanche to the points you make that we should be reassured that everything is fine. Because frankly, we cannot make an informed and intelligent decision because we do not have all the facts.
There's quite a lot in there, and taking your earlier comments, Chair, it's probably unwise for me to try and unpack every point Mr Jackson's made, but just a few of those. The 2005 Act, as I tried to explain earlier, circumscribes our rights as commissioners. Section 20 is the section that deals with public disclosure. It isn't a general right, it's a specific right laid out in the subsections that follow. Section 18.2 is the section that disapplies the prohibition. Again, it is very specific, and as I said to you earlier, I can find no evidence we have any common law powers that take us beyond our forming statute. I owe you a different duty, and I am very serious about that, and that is as accounting officer to you as a parliamentary committee, and that is governed by the Government Resources and Accounts Act, which requires me to prepare resource accounts, and I have signed this year's, and I understand Amias has also now signed them, and to account to you transparently with integrity and to the best of my ability, and I will do that. But that is not the same, in my view, as simply opening all of our documents to you. And I have no desire at all to be disrespectful, but my view is you are no better placed to judge the capability of my tax experts than a judge or than the people I have at the top of my organisation. And my duty is to show you that I am managing the resources given to me with care, and I intend to be... I appreciate that.
We were elected, and we have duties out of that.
I understand
to the people who elected us.
And I am very keen, within the powers that are given to me by the statute as a commissioner and as my responsibilities as accounting officer, to be as full as I can with you about general information. What I would take a disagreement strongly with Mr Jackson on is the capability of our organisation.
I'm asking you a question. We're not in a position to make a value judgment on the efficacy of those individuals.
Right. Well, I am very happy
because
to
we
try
don't know
and
about
give
them.
more information to you, both about the generality of our numbers, about the way we train people, the way we check them, and would be delighted to open up more of the information.
None of your lawyers, for example, in the evidence we had were tax lawyers.
That's not true. We have a number of lawyers who are tax experts.
It's the top four.
Well,
The General Counsel and his 3 direct reports, the 4 most senior lawyers within HMRC are not tax experts, and the tax commissioners, until recently, only one of them, as I understand it, Mr Hartnett, actually have a detailed knowledge of tax. And as we know from the Vodafone settlement, 2 tax commissioners went along, got it wrong, and then didn't refer it to anyone else for sign-off. So the question, I can't refer back to what was a private session yesterday, but the point is, I don't think it's this committee is suggesting that members of your department do not have tax expertise. I think there's many very well qualified and expert tax professionals within HMRC. The frustration of this committee is key decisions, important decisions, were taken without the benefit of their advice.
That is not true. Key decisions were taken in the department with the benefit of advice. That advice does not necessarily constitute the same people at every stage of.
But you took the technical, case of those decisions. You took the technical people off. Mr Hartnett went into the driving seat with people who didn't know the technical details. That is, well,
that is not.
We will only be able to judge it. That is what is in the public domain, Lynn.
That is not.
And we can't judge it. That is our view until we have evidence.
And you didn't take a note of the meeting. It would have been helpful if the department took a note of the meeting. You actually rely, in the case of Goldman Sachs, on the meeting and the meeting note provided by the taxpayers. It's a quite remarkable state of affairs when you phoned the head of global tax from Goldman Sachs, get him to fly over from the States to a meeting of such importance that you are addressing, we'll come on to Goldman Sachs, a number of issues, and you don't even take a file note.
What you actually do is reach a deal, and this is the world, this is the reality. You're saying that's not true.
Let me put this to you. if you're in a there are negotiations, Lynn. Are there negotiations?
There
are discussions.
There are discussions.
Okay, so it cannot, if there are what you call discussions, what I would call negotiations, it cannot be true that you always settle on the figure that is legally due. It must be true that in some cases you settle for less.
We don't settle for less than we could reasonably expect to get in
No, that is
litigation.
legally due.
That is not the phrase I used, and I'm trying to explain our strategy to you, because one of the issues that was described yesterday is that the areas of law we're talking about are incredibly complex. I think that's agreed by everyone. There isn't a situation in these cases where there is a right answer and a wrong answer, and if you just
So
search
you
long
do
enough, you
settle.
can find
I
it.
understand that. Let me just pursue this and then you can come back. So you do settle. You have a view on what is legally due.
Yes.
And then you settle for less than that because you make a judgment on what you're going to get in the courts.
We settle for what we think we would get if we litigate.
No, but
No.
that's
That's with
different
respect.
from
That's
what is legally due.
with respect. That is not the evidence we heard yesterday. It was
That was
stated quite clearly.
The
Quite
judge's
clearly by the
opinion.
judge that I think the word he used was inherent. Inherently, he said, you'll end up settling for less than you would get if you go to litigation because of all the other associated costs of litigation in terms of time and administrative cost and risk and all the rest of it. So inherently, you settle for a slightly different and lower number. That's what he said.
That was the judge's opinion, and what I'm telling you is that within our strategy, I think we seek to achieve a more purist position than that. There is an area involved in this which you will understand from your own experience as MPs, and that is that at times you seek to establish the parameters of a legal position. And what I think is evident in the cases is that we sometimes take that quite a long way, and we get settlements that are, I think the judge has commented on more than one of these, that if we had litigated, we might not have got anything. And so it would be wrong to suggest that we're other than pretty fearless in those, but we are considering what the judge would determine in cases where there is not a single settled view, and that is why we're trying to anticipate litigation. And I am very clear that we do not want to move away from that position. We do not think it would be right for us to make our own mind up about what would be a fair deal. We are seeking to mirror what we would get in litigation quicker and with less cost and in a way that can then be applied to other cases.
Script in this regard, and I'll say no more than that. I think what you've just said then comes back to something Mr. Barclay was talking about earlier, which is if you don't have that assessment that you're referring to now about what you would get from litigation, you can't know whether a settlement is reasonable or not. And I think that we haven't had the comfort, maybe just because we haven't had the information, we haven't had the comfort from the report or from the evidence that in each of these cases, and indeed maybe other cases, that the sufficient assessment of the litigation, the likely outcome of litigation, was actually kind of there and recorded before the discussions took place, because Mr. Barclay was trying to press, well, was this a number you had during, before or after? And I don't think we got clear answers. But if you have got the process that you described, then you would have the numbers, because you would have some kind of assessment of the likely outcome against which to judge, if you like, the business case of should we do this, should we not, should we delay and go for another round of legal work or whatever. I don't see how you can actually make that judgment unless you've got the numbers up front.
Chair, if the committee would like, I'm very happy to suggest a session with some of the senior people from business tax where we talk in general, but around a table about the way we determine these cases. We have no desire to hide our process from you, and I think the position in relation to assessments, my expectation is that there will probably be judgments at various points through some of these cases, because one of the purposes of the litigation and settlement strategy, which we believe has been really successful, is it draws more information from the company into the dispute. And in doing that, that will sometimes enable us to say that an amount we may have thought was due isn't, because there is a legitimate relief, or in fact to say that some amounts that we thought were out of scope should be brought in. So it would be wrong to see this as view, argument, end game. This is a discussion and a judgment, but what I'm trying to give you is a clear reassurance that as that information is available, our end game is to get the tax we believe is due, not to get the best negotiation.
I mean, I just observation that I'm going to bring Nick in. Were it true that that was the basis, we would see much more litigation.
Well, there is a great deal of litigation, and we're very successful. There is a great deal of litigation generally, and we're very successful.
How many of the big corporations that you're looking at are you currently in the courts on?
Okay,
Well, currently in the courts.
Okay, I can get Marks and Spencers. That's in the public domain. We are litigating with Marks and Spencers on
Well,
the group
maybe if you get in the public courts, you're in
it's in
public domain.
It's in the public domain that we litigated with Vodafone on some of the issues that we've
Yeah, but you
looked at
then
today.
didn't sue that.
There's a whole range of, it's all a matter of public record. There's a whole
Go
range
on, how
of
many?
litigation where we do.
Marks and Spencers, Vodafone, which you then won and then ignored the fact you'd won.
I'll read you a list of cases that have been published in recent years where we have litigated, which are large corporates: Littlewoods, Legal & General, Philips Electronics, HBOS, JW Wetherspoon, Countrywide Estate Agents, Aberdeen Asset Management, Reed Employment, Marks and Spencers I've managed.
And how far back are you going here?
This is in the last few years.
What's few?
There are currently
What's few?
There are currently just over 4,000 live litigation cases in our solicitor's office. That's
How many of those are large corporates?
I don't have figures for how many of those are large. I can describe for you significant cases that are either live, that are large, or that are recently litigated. But it is our practice where under the litigation settlement strategy to seek an agreement if we can, but we constrain ourselves through our strategy on the basis on which we will agree, and if we cannot reach agreement on that basis, then we will litigate. We give ourselves perhaps less freedom than the large corporate does, who might well bring in
Mr. Harra, just tell me, how these are a few years, just get it clear, how many years?
I don't have details of how old all of those are. They are in they're in recent years.
I'm surprised you don't know. I mean, large corporates are a small subset. They pay most of the tax. I think some very high percentage of the entire tax take is from the FTSE 100.
60%.
If I can describe, the HBOS case I mentioned 2009, the Scottish Widows case I mentioned 2011.
So, Mr. Harra, I'm really interested in how many live cases there are among large corporates. Now, you're the Director General of the Large Corporate Division, I would have thought you'd be across that.
I don't have the information with me on the numbers, and I would not like to give you the wrong number. It's over 4,000 with our...
Yeah, but 4,000, there aren't 4,000 large corporates. I'm not asking you to sign your name in blood, and if it turns out to be wrong by a factor of 10, no, not by a factor of 10, by a number of 10, then please write us a note, say so. But what I'm really asking is, for example, of the FTSE 100, is it 2? Is it 98? What is it roughly?
I'm not going to guess a number. I will write to you.
Is it because it's so low that actually... I mean, you know, you might be right that it's a good thing that it is low, because your policy is to negotiate where possible, and they know that, and you're such hard ball players that... sorry, I used the wrong word. To reach a settlement where possible. Yes, I'm sorry, I misspoke.
And we will give you a list. It's one of those things that by this stage of the hearing you've
well, it's such an obvious thing we'd ask, because you're trying to say to us, we settle, we don't negotiate, we do what's right.
Well, we do.
There's such obvious, Lynn. This is just common sense stuff. If it's what's right, if you actually always go in for what's right, then you would end up in the courts a lot, and I don't see that in my general reading.
Well, I think the question here is what you notice and what you don't. I want to make 2 points. One is that for us, settling the large sum and litigating the large sum are both appropriate ways to go forwards, and part of the move towards the litigation and settlement strategy was a view that it was better to settle, and I think in your report of a couple of years ago, I guess before your time as chairman, Mrs Hodge, the encouragement for us was to settle cases more quickly, and over 85% of our cases are now settled within 18 months. But at the moment, we have the thin cap group litigation order, which is in the Supreme Court. We don't believe it's going to be appealed. We have Shiner and Scheinman, which is in the Court of Appeal. Permission to appeal has been refused. We have the Eclipse case. We have the Tower End cashback case, which is in the Supreme Court. Gaines and Cooper in the Supreme Court. PA Holdings, Hankinson, Birmingham Hippodrome Theatre Trust, Glaxo, AXA, Carlsberg, Channel Islands, Pendragon, Findel. All of those are ranging from first-tier tribunal up to the Supreme Court, or as House laws as it would have been. They range from a few tens of millions to billions. So it is absolutely wrong to suggest that we're not prepared to litigate. We don't litigate if we can settle, because the amount we settle for is what we think we would get in litigation.
Nick.
Thanks, Chair. It's a quick question from me. I just wanted to return to this correspondence from Mr. Morris of Vodafone. I just want a little bit more transparency about this Vodafone letter. I think it's fair to say in Mr. Morris's letter that he's critical of the Reuters article. He says Vodafone pay fair tax in the UK. He's got some quite hard figures in it about them paying 8 billion of taxes over the last 12 years, and then he talks about the 6 billion paid for the spectrum licences. However, there's no figures in this note he's done for us for the interest payments on the money they borrowed to pay for the spectrum licences, and therefore the tax benefits on the interest that they could have claimed. Is this information publicly available to us? Can we know what's going on here?
I'm not sure I understood. We think published accounts?
So it will be available in the Vodafone published accounts of the interest they're paying, and therefore the tax benefits they got.
There's not, Mr. Smith, a necessary causal clear link between the two for the reasons I gave earlier on about other reliefs that might be there. But the interest payment should be there year on year.
It should be fairly clear what the tax benefits on those interest payments are, isn't it?
Not as clear as
You try and make it simple for us, would you?
Yeah,
and simple for the British public.
Yeah.
Well, rather than just hiding behind the complexity. It's so irritating. Just, that's a simple question there. Interest can be disregarded for tax, can't it?
Yes.
Right. Well, so it should be clear, shouldn't it? And if it's not, why not in theory is it not?
Tax is complex, and
No, interest payments. We're talking just about the interest payments.
Mr. Smith, sorry.
I'll repeat what I said earlier, which is that in the tax system there is general tax relief for interest payments on borrowings. You would expect a large corporate, if it is borrowing for the purposes of its business, to get tax relief for the interest. In its accounts, I'm sure you'll be able to see the interest that it's paying. You won't see details of its UK tax computation.
So, back at the envelope numbers, they spent 6 billion on these spectrum licences. They'd have paid interest on that. How much would they have paid? What were the tax benefits
If they borrowed
on that interest they paid? They're paying.
If they borrowed it all.
If they borrowed.
How much?
They borrowed it from themselves,
Questions we
didn't they?
would be looking at, Mr. Smith. How much did they borrow? Did they borrow more or less than the cost of the spectrum?
Did they borrow it from themselves?
Exactly. Did they borrow it at arm's length? Did they borrow in the UK, or did they borrow somewhere else? Was there actual tax relief? And what I mean by that, was there a residual tax bill to pay in the year so that you could actually say it was 300 million of interest, that's a guess by the way, 300 million of interest at 26%, or actually was there no tax remaining payable? And I'm really sorry about this next bit, does it become a deferred tax issue, possibly the most complicated bit of the public company's accounts, or what? and I give you that simply to show we can't clearly throw out a precise figure from the accounts of the tax consequence.
Well, Chair, the reason I asked that question is that Vodafone are quite clear about the amount they paid in taxes, and it's a fair chunk of change, but it's not clear what tax benefits they've got from the interest payments they made on these licences. If you're going to have a balanced appreciation, it's fair to get all the information on the table.
We're back into your position on tax transparency, Chair, and I've no doubt you're going to continue to hold those beliefs, but I'm not sure there's much more we can say in that space.
Well, all we can regard is Vodafone, if they really want to be believed, should give all sides of the picture, and not just one side.